Hey, hello everyone. Welcome to our webinar, first of the Polish group, and let's hope that's just the beginning. So for the first time, we have our webinar dedicated to design reform, New Year, New Me, notes from the Design's Diary. And today we'll discuss all the changes, at least all the major changes that are introduced to the design law. And today we have three speakers who will tell us about certain points of the reform. First will be Paweł Poznański, then we'll have Marcin Faron, and then Krystian Petz. And after their presentations, we'll have a brief discussion about the subjects we followed and maybe we would like to discuss more about. And with a bit of housekeeping, if any of you face any problems, please use the chat box to communicate those problems to us. And after we finish our webinar, you'll receive a brief survey to give us your feedback. So I won't do it any longer. So the Paweł and the guys have enough time for their presentations. So please, Paweł, the floor is yours.
Good afternoon, everybody. I'm very glad that I can present during this very first webinar of Young APPI Committee from APPI Polska, Poland, and I'm happy that I can share with you some comments on EU designs reforms that are happening right now and tell you what will happen in the future. And during the presentation, I would like us to consider whether this reform provides us only with terminology shift or maybe with real substantive changes. So during the presentation, I will try to prepare a response to 4 of these questions. First of all, why there's a reform? What is the subject of these reforms? When will it all happen? And what are the main changes that are provided with these design reforms? So far, we had these 2 legal acts. First, it was directive from 1998 on legal protection of designs and Council regulation from 2001 on community design. As we can see, more than 20 years passed since enactment of these legal acts, actually almost 20, more than 25 in the case of directive. And during that time, many things had happened. I mean, many things change in the market. We've got more digitalized market. We got changes that may mean that these legal acts maybe are not appropriate, are not suitable for the challenges of designs, of digitalization, and for example, 3D printing or with AI. So there were consultations, there were revisions, there were so many discussions on what should be changed, how it should be changed, and after not that much time, we had a commission proposal that went that smoothly that right now we have new legal acts that are almost of identical content of what we've had in the commission proposal. So we have a regulation that is replacing earlier regulation on community designs, and we've got new directive on the legal protection of designs, but we are not completely new legal acts because these earlier legal acts were like fundaments, and right now we have like an upgrade to be more up to date to the current challenges and be more approachable for designers and small and medium enterprises. As you can see, both acts were entered into force on 23rd of October, but the provisions from these acts are still not applicable yet. We have to wait some time, and as for applicability, we may divide it into some phases. The first phase is ending at 1st of May. Most of the provisions of the regulation on the EU designs will be applicable since 1st of May, but there are some provisions that require implementing secondary legislation. By secondary legislation, I mean implementing and delegated regulations for which we have to wait a little bit more, and these provisions will be applicable as of 1st July 2026. And the third phase, as we may say, will be since when applicable will be provisions that are in the directive that will be transposed into the legal laws of each member states. Here it is written that member states will have a period of 36 months to take the necessary steps for the purposes. That is until 9th of December 2027. But the truth is that some countries actually will have less time because, for example, in Poland, cadency of our current parliament ends in more or less October 2027. So it would be good if Polish parliament transposes the directive until the time. If they will not manage to do so, it would be a problem with transposing the directive for the next parliament that will be elected afterwards. So moving to the main changes. First of all, naming. For some people, it may seem like it's like just a slight change, like it's not significant. I mean, this moving from community design to European Union design, from unregistered community design to unregistered European Union design. However, in my opinion, it's quite important that finally we have this change because we are not living in European community since 2009. We've got European Union trademark since 2016. And for European Union design, we have to wait until 2025. So for me, it's a proof that, well, politicians did not forget about designs, but I don't understand why it took that much time, but finally we have it. Other new symbols, other new things that are like other new symbols that we have, for example, for rights that already had it, is this, as you can see, a registration symbol. Because, for example, as for copyrights or trademarks, we had such symbols for so many decades, and at last we have it for designs. This design symbol can be put on the product that is registered as EU or just industrial national design. It can be accompanied by a hyperlink to the registration or by the registration number. And in my opinion, it will increase design awareness, but it has also there are also some risks related to abuse of using this registration symbol. And if I will have more time at the end of the presentation, I will come back to that issue. Definitions. We've got new definitions of two major concepts of design and of product, but actually they're not brand new, but they are just extension of what we had until now. Because as we can see, to definition of design, there is added that it's also related to the decoration, including the movement, transition, or any other sort of animation of those features. So it's more suitable right now for new forms of designs, more digitalized ones, and the same is applicable for new definition of product, which right now not only refer to item that is physical, object, but also an item in a non-physical form. So it gives opportunity of filing for a design that is completely detached of physical object, but is composed of something that, for example, is consisting of visual effects created by a light. And until now, it was not that clear whether we can file for that kind of product as a EU design. There is also extension of examples what can be a product. So many examples like packaging, sets of articles were already in use, were already allowed by the UIPO. But what is surprising in that in these examples is, for example, symbols and logos. We are associating these kind of things with trademarks. That trademarks are more appropriate for protecting symbols or logos. There are some cases where people want to file for a sign, but they are not filing for trademark, but for design. And I'm afraid that this extension of product definition will encourage people to file for more. It will create more situations like this, where people, when they will know that they will not be able to have trademark, will try to have design protection for symbol or logos. And there are also new grounds for registrability, but it's not certain whether it will be in every country, because it is written in a directive that member states may provide the design is to be refused registration where it contains a total or partial reproduction of elements belonging to cultural heritage. So it means that member states may, but it is possible that they will, that not every country will provide this kind of new ground for non-registrability. If you are wondering what does it mean cultural heritage, you can check at Convention concerning the protection of the world cultural and national heritage adopted by UNESCO, but mainly it refers to monuments, handicrafts, or costumes. Within this reforms, we've got also new right confirmed. In this provision, we don't have directly mentioned 3D printing as a form of use, but this provision, as we can see, directly refers to combating illegitimate 3D printing. We've got also new limitations envisaged, which means that if there are designers who are listening to me and they are good at comment, critique, or parody, feel free to use designs that are registered, because if you will do comment, critique, or parody, it will be within law and you will not infringe this registered design. As you can see, the fees are simplified, because before reform we had two fees, one for registration, one for publication. After reform, we'll have just one fee for registration, which will be of the same amount, 350 euros. We've got also so much simplification in multiple applications, because until now we have to think whether it's from until 10th design or more than 11th designs, whether it's for publication registration. Right now we will not have to bother about it. There will be just one fee covering all these issues, but as you can see, this fee is higher than it was before. And increasing of fees not only refers to multiple applications, but also to the renewal fees. As you can see, some fees for example, third or fourth renewal are triply or quadruplicated than how it was until now. In my opinion, if design is successful, it should not be a problem for a design owner to pay this fee, because it's not a high amount of money for protection for entire European Union for design for that much time. But in my opinion, if it will be still quite much for a designer to pay, and he will know that he will not be able to pay this following fees for second, third, and fourth year, maybe this increase of fees is also like a signal for designers that they have a choice. They don't have to always file for EU design. They can file for national design in countries where they just need to, where they have their main interests. There are so many other relevant changes that I can comment about, like unity of class requirement that is abandoned for multiple EU design applications, that EU designs will allow their holders to seize counterfeit goods in transit, fast-track invalidity proceedings, or a repair clause. But unfortunately, I have to stop here because we've got limited time for presentation. But as for this last issue, repair clause, my colleague Marcin will elaborate more on this issue. So thank you for your attention. Bye.
Thank you very much, Paweł. I think it was a great introduction to the changes. And now, as Paweł mentioned, Marcin will tell us more about the repair clause. If you can share your screen.
Hello, everyone. It's my turn. So, do you see my presentation?
Yes, you just have to change the mode. Perfect.
Great. Okay, so welcome to my presentation on the repair clause in EU design law. Today, I'll be discussing how the repair clause has evolved, where it stands now, and what to expect in the near future, especially in the light of the new design package. To start, let's look at our main objectives for today. First, I'll provide a quick refresher on what the repair clause is and why it's important. Then I'll discuss its history and evolution in EU law, covering the pros and cons. Following that, I will provide an outlook on the proposed changes under the new design package. I will try to answer what challenges we are going to face in accordance with the new design law. And by the end of the presentation, I hope you will have a clear picture of where we are now and where we're headed regarding the repair clause. Generally speaking, the repair clause is one part of the right known as right to repair. It consists of several regulations such as competition law or regulations on product safety. In the field of intellectual property law, it's regulated in the design law under the name repair clause. It's a limitation of design right which allows to use protected design for the purpose of repair of a complex product so as to restore its original appearance. It's possible only where the design is applied or to or incorporated in a product which constitutes a component part of a complex product upon whose appearance the protected design is dependent. The repair clause primarily finds its roots in the directive, which is mentioned on the slide. Before harmonization, member states approached parts quite differently. Some allowed more liberal access to design protected parts, and some other restricted it to protect original manufacturers. That was problematic for a single market. And the lack of unanimous agreement among all member states to introduce a repair clause limitation into their own national legal systems led to the requirements set forth in Article 14 of directive to either maintain the status quo or to liberate national law in this area pending a uniform EU-wide protection. The upshot, we have uneven playing field which complicates cross-border transactions. So hence the push for the new reform. Moving on to the pros and cons, let's start with the advantages. First, consumer benefits are a key aspect. By allowing competition in the spare parts market, the repair clause helps keeping prices down and ensures consumers have access to multiple suppliers. It's important to realize that spare parts market is limited to the products with long useful life. Consumers should therefore have a choice between parts manufactured by the original manufacturers and cheaper spare parts produced by independent spare part producers. Because of that, a repair clause is strictly connected to a free movement rules of the EU market. Second, it fosters healthy competition, preventing manufacturers from monopolizing the aftermarket. It also contributes to sustainability because it supports a culture of repair rather than a replacement. On the other hand, there are some downsides. One is the risk of weakened design protection, as manufacturers may feel less inclined to innovate to protect their designs if their designs are easily replicated for spare parts. There's also the risk of abuse, where parts are produced not just for the genuine repairs, but to flood the market with replicas that go beyond necessary repairs. And finally, enforcement complexity is a real challenge. Authorities and courts have to determine whether a part is genuinely for repair or infringement. As we'll see, the Court of Justice has stepped in to clarify, not always with success, some of these ambiguities. At the core of today's EU design protection are directive and the community design regulation. While the directive opted to maintain the status quo with an exception permitting the liberalization of the design law in relation to the repair clause, regulation introduced a temporary repair clause in Article 110. For this reason, the repair clause has been interpreted on several occasions by the Court of Justice. Notably, the EU Court has either avoided answering the questions posed or has adopted a completely different approach towards the repair clause. Particularly in Acacia, the Court of Justice emphasized that there is no form dependency requirement in EU design law, although it was a classical requirement for repair clause. The court adopted a broad scope of repair clause and stated that a part is a component part whenever without that use, the complex product would not be subject to normal use. And one of the most significant issues involves the so-called horizontal effect of the repair clause, namely how it impacts on other intellectual property rights, namely copyrights and trademarks. Restoring a complex product to its original appearance may necessitate placing the manufacturer's trademarks or other signs on the spare parts. According to the court's current view, as confirmed in Audi, the limitations on trademark rights have been exhaustively regulated by the trademark directive. So it's not possible to incorporate the repair clause as an additional restriction on trademark rights. Okay, looking ahead, the new design package is set to bring about further harmonization and clarity. The new provision specifies the component parts of complex product will not enjoy EU design protection if they are solely used for repairing purposes aimed at restoring the original appearance of the product. The new repair clause is regulated identically in both the regulation and the directive. However, the directive, as Paweł mentioned, stipulates a transitional period until 2032, during which the clause will not apply to designs filed before 8th of December 2024. Member states must transpose the directive with respect to the repair clause by December 9th, 2027. The new repair clause, as you can see, explicitly introduced a form-dependent requirement, meaning the broad interpretation of the repair clause approved by the court in Acacia does not apply. It also imposes in paragraph 2 specific informational obligations on spare part manufacturers, and if these are not fulfilled, they cannot invoke the repair clause. Conversely, under paragraph 3, such manufacturers are expressly exempt from liability if spare parts are used on the secondary market for purposes other than repair. Some questions must be answered in the near future. First, the form dependency requirement raises questions about its interpretation. It's connected with the scope of repair clause, namely what parts are really spare parts. For example, the court in Ford's order analyzed the repair clause in relation to the wheel covers, although the status of wheel covers as spare parts is arguable. Second, the due diligence obligations are set on stricter level than it was established in Acacia. Let's be honest, terms like commercial origin remain unclear. While the recital state it includes at least the manufacturer's trademark and names, it's uncertain whether these alone suffice in every case. Thirdly, the relation between repair clause and other intellectual property rights, mainly copyrights and trademarks, must be re-examined. Even though the repair clause relates specifically to design's regime, it's crucial to remember that copyrights and trademarks laws still apply. In practice, this means that manufacturers or independent producers can rely on the design repair clause to override other valid IP rights. Thus, the interplay between these different legal protection systems can be complex and requires careful navigation. To conclude, the repair clause in EU design law has a profound impact on competition, consumer rights, and sustainability. We're moving toward a more unified approach that supports consumer needs and the right to repair, but design owners still have significant rights to protect their innovations. But it's all a theory. Several questions should be asked, and I think now we have to wait for answers. Thank you.
Thank you very much, Marcin. That was very interesting, and I think it answered some of our questions about the repair clause. And as you mentioned, now we have a problem or something to discuss about relation between the design law and other regimes like trademark and copyright. And I hope that is something that Krystian will help us resolve and will tell us more about. So Krystian, the floor is yours, and please share your screen.
Sure, thank you. Just give me 1 second. Can you see my slides?
Yes.
Perfect. So thank you once again for the floor. And I'm very happy to be with you today. Today I'm gonna talk about on a personally very interesting phenomenon that occurs in IP. And I would say that is naturally related to design protection. And as Julia already mentioned, I'm gonna talk about cumulative protection in IP. So just very quickly, in my presentation, I will first introduce you to the concept of cumulative protection. Then I will present 3 key rulings that are significant from perspective of cumulation of both design and copyright protection. And finally, I will address the design package and some references to the newest amendments that relate to the issues I'm gonna present. So, cumulative protection in IP law refers to the simultaneous protection of the same intangible asset under multiple legal regimes. So it means that a single creation, for example, a design, can be protected by different types of IP rights at the same time, and each offers a distinct scope of protection and duration as well. So, for example, a product design may be protected, of course, by industrial design protection, by copyright, by trademark, and also by unfair competition law. And this phenomenon creates a stronger position for right holders because it offers them a broader coverage and additional remedies in case of infringement, for example. And balancing the layers of protection nowadays is a key issue, especially in a modern IP law. Cumulative protection poses many challenges, and they are actually a real thing. So it's just not a theoretical problem. Let me briefly present these issues that we are facing now in EU case law, because currently we have these 3 rulings that concern the accumulation of design and copyright. Starting with the first case, the FLOSS case. The ruling of the CJEU in this case marked the beginning of a significant legal debate regarding the protection of design with copyright. And this case involved a dispute over the infringement of FLOSS copyright on the Arco lamp. At that time, it became an iconic design object. Before the implementation of the design directive into Italian law, the protection of design was subject to the requirement of so-called separability. So it meant that the artistic value had to be distinct from the industrial nature of the product. And primarily, at the beginning, this made it difficult for design to receive copyright protection. But following the implementation of the directive that removed this separability condition, it became possible for design to receive dual protection, both under copyright and design, as long as the design itself was creative and had the artistic value. So in this case, the court clarified that the duration of copyright protection for designs in the EU is uniform, and it lasts for the life of the author plus 70 years. That was already clear. On one hand, but on the other hand, it left unresolved questions regarding the criteria for protecting design as a work of art. The next character in the story, the Coffemel case, addressed the protection of so-called applied art under EU law. it focused on whether the fashion items, for example, clothing, could qualify for copyright protection. And this case arose from a dispute between G-Star and Portuguese company Cofamo that allegedly copied G-Star design. So the key question in this case was whether works of applied art could be protected by copyright and what criteria should apply in such case. Portuguese court required a distinctive aesthetic effect, but European Court of Justice rejected this, and it ruled that the only requirement for copyright protection is originality, of course, and not subjective judgments or not artistic quality or beauty. So this case highlighted differences between copyright and design protection, and two approaches emerged. One, accepting limited freedom as a compatible with originality, and another one with denying copyright protection in such cases. The European Court of Justice acknowledged the tension between the two systems, and it suggested that the cumulative protection should remain an exception, though this principle is still very unclear and sometimes very, very contradictory. The next case dealt with a copyright dispute over a folding bicycle made by Brompton Bicycle, whose patents to the folding mechanism had expired. So the key question was whether the technical functionality of the bike's design affected its eligibility for copyright protection. The European Court of Justice had to determine if the exclusion of protection for functional features that are common in patent law should also apply to copyright. The Advocate General in this case argued that designs driven by technical considerations should not qualify for copyright, especially when functionality and aesthetics are closely linked. He also noted that a creator's intent, for example, aiming for mass production, should not affect copyright eligibility and copyright protection. Instead, protection should be based only on originality, but not commercial motives. The court clarified that copyright protection would apply even if a design served a technical function, as long as it allowed for creative choices that reflect creators' personality. The shape, in this case at least, must be necessary for a specific technical effect, but national courts must ultimately decide whether originality exists or not. And the court ruled that a design isn't eligible for copyright if its form is purely functional, and when it lacks creative expression. However, if technical constraints will still allow room for creative freedom, the design might be protected. So the focus should be on the creative process rather than the external factors, for example, commercial intent. Okay. So we have these three rulings in European Union case law, and now let's see how our legislator is going to handle this in the already mentioned design package. So let me say at the beginning that I'm not the biggest fan of these proposals because they do not fix the current situation that was established by the European Court of Justice ruling. Specifically, the issue of defining the overlap between copyright and design still remains unresolved, right? So the CJEU failed to establish its own criteria that would provide a solid foundation for effectively harmonizing the concept of work, both legally and practically. And as a result, it is still unclear whether national courts can continue applying specific criteria for delimitation, and whether such criteria can align with the court's statements, and because sometimes they're very unclear. If courts are indeed required to completely abandon the use of delimitation criteria, this could lead to a significant reduction in the threshold for copyright protection. It would potentially cause various problems in areas where copyright and design overlap. For example, in case of circumventing restrictions that apply to design but not to copyright. The next point in the proposal that raise a concern is a reference to the requirements of the Union copyright law. So this reference is truly incorrect, because in IP, referring to Union law, for example, trademark, implies a unified right that is applicable across the entire European Union. But we know that such a unified right does not exist when it comes to copyright under European law. And also, as noted in recital 33 of the proposal of the directive, copyright has not been fully harmonized. Instead of using potentially confusing terminology, the law could either refer to the autonomous concept of work as defined by the CJEU, or alternatively maintain the current wording, because the standards referenced must align with the current or future level of harmonization. So shortly summing up, we are facing, first things first, problems with the limitation between copyright law and design law. We are facing a lack of full harmonization of copyright law at the EU level. At the same time, we need clarification regarding national law and CJEU jurisprudence. And I think, and yeah, that was it. That was my last slide. Thank you so much for your time. And I hope this presentation was at least not less interesting than my previous speakers. And I'm giving floor back to Julia.
Thank you very much, Krystian. I am sure that everyone enjoyed it. Yes, we touched various problems that we face with the new propositions of law, and they're not only propositions, they're just binding law. But I think we have some more time to discuss a few of the issues that we discussed, that you talked about in your presentations. And I wanted to ask you about the idea of these changes. This is something that Paweł already mentioned. It's in his presentation. We have this new definition of a product that is making eligible for registration also non-physical items. And that introduces a whole new range of protectable objects. And do you think that it's more of a matter of definition, that is only wording that is changing, or we are facing a complete change of perception of a design? Because we know that GUIs are already registered as designs. The same goes for logotypes, but is it something entirely new that we have to face, or it's just wording and everything will stay basically the same?
I can try the first question, apparently. So I think it's both. And it's like a mix of these two things you mentioned, because on one hand, I would say, I would describe it as a natural evolution of how things have been developing for many years already. But on the other, it's a shift in how we see design and product protection. So the thing that I mean is, in a way, this new definition simply formalizes what's already happening, right? Over the past couple of years, even decades, the intangible assets, the brand identities or NFTs, etc., they have become incredibly valuable, and we've already been protecting such things, but through other legal regimes like trademarks, for example. So this new definition just brings everything together and makes it more clear that these digital elements deserve the same kind of protection as physical products, for example. That's one thing, but I think that on the other hand, it's also the way we consider non-physical items. I mean that we're no longer thinking of products, of physical products, something you can hold in your hands, but with virtual realities or metaverses, it became mainstream. So non-physical items are just as real and valuable as traditional ones. So at the same time, it also forces us to rethink what a product really is nowadays. I think so.
Yeah. Would you like to add something, Marcin, Paweł?
I may add something. So in my opinion, this indication that product may be a non-physical item may open the door for so many experiments. I mean, like people will try to apply for not only appearance, as we see, like from like direct appearance, like also any effect that it creates. So there will be so many experiments of registering something that is non-physical in order to protect design in its entirety, whether physical or non-physical. And I'm really curious what would be the results of this kind of experiments.
Yes, thank you.
And maybe
And yes, Marcin, please.
I think that it's not just a mere change of the names, but I think how it impact on the infringement of the enforcement and the institution we know, yes, individual character or overall assessment. It's in online infringement cases, I think it will be very difficult to assess the key aspects of infringement proceedings as we are used to, yes, because it's completely different approach, I think.
Yeah. And also you mentioned, Paweł, in your presentation that you would like to say something more about the design that is introduced in accordance to TM sign and C for copyright as we know it. Do you think it will be more an opportunity for design holders or more of a place to abuse this sign and to gain more than it is indicated by the registration?
Well, primarily, I think that it will be something that will serve as spreading design awareness. So it will be a plus for designers, for design owners, because, for example, thanks to this design notice, people who don't know what is registered design, they will see this sign, this symbol with or without registration number or hyperlink, and it will spread the awareness. More people will know about it. But on the other hand, in trademarks with R in the circle, there are some situations where people are putting that symbol when they should not put it. I mean, the trademark is not, the sign is not registered as a trademark, but they are giving impression as it is registered. So I'm afraid that it will similarly happen with designs. People will put this design symbol, design notice, even in situations where we will have design that is not registered, and it will create a false impression that it is an exclusive right while it is not. So we'll have to be cautious, and if we see this design symbol, we sometimes maybe will have to verify whether it's a real registered design or maybe just a fake notice.
Thank you, Marcin. Krystian?
I just wanted to add that I'm fully agree with Paweł. Like noticing or like putting a D on a product may actually cause even more. It can be confusing for consumers.
Yes, and we have to.
I mean, because it's
keep in
already
mind-
happening with like trademarks, for example,
Yes.
just like random putting a notice on a product.
Yes, I think it's also valid to mention that we have unregistered designs. So how do we actually check if the design still has the protection, but as an unregistered design, was it given a symbol for only the period of time that it was protected, or it was somehow maneuvered then? How it applies. Marcin, would you like to add something?
Yes, I just wanted to say that we should think, I mean, national legislatures should think about introduce some criminal sanction system. Yes, we have in Poland, in Polish Industrial Property Law Act, we have some provisions about the TM system, TM sign. Yes, so we should think that the national authorities should introduce some criminal sanctions for misuse of such signs.
Yes, exactly. And yes, I wanted to ask you just a few more things. I think that while analyzing all the new provisions of protection of the designs, it's quite visible that it leans more towards the protection similar to the one provided for trademarks and copyright. And I mean something like exclusion from protection indication of the product's origin, or using the product with the purpose of critique or parody. And how do you feel about it? Does it seem a bit unnatural for the design realm, or do you feel that it's the right way? Something maybe that Krystian mentioned, that there is no like unified copyright law, and maybe this is the way of making all the provisions from copyright, from trademark, and from design very much similar, so they can be interchanged.
So am I supposed to respond? Because
you can start. Yeah.
Okay. Because you said my name, so yeah. First of all, so this idea of like borrowing from trademark and copyright, I think it's I would call it a double-edged sword, because sure, like beefing up design protection by including these elements could be great for designers, especially with how fast things are changing in the digital world, for example. But if we start saying you can't use designs for things like showing where they come from, we could run into some real problems. For example, in case of parody or critic. And I also think it could at least create some legal headaches. I don't know. I just called it like that because like mixing trademark into design law could make things even more unclear that we're now already observing, right? And it would be tough. It would be difficult for courts to figure out what's okay and what's not. Because we are also observing that, especially in Kafamol case, when the court just didn't know what to do. So yeah, I think that's my opinion on it. So it's like it has some pros and cons.
Yeah. Marcin, Paweł, would you like to present your point? Do you agree or you have a different view on that?
I agree with Krystian. But to be honest, we should look at it comprehensively, and if we include in the design definition logos and other new things, then we should include some limitations which are normal for copyrights or trademarks, because I generally think that we should include other regimes, because cumulative protection and collisions of different regimes are normal situations. So we shouldn't, I mean, the legislature shouldn't allow to create a limitation in one regime which doesn't have its own counterpart on different regime. Yes, so I think generally that it's a good thing to include such limitations.
Paweł?
But you mean, Marcin, this limitation would be created when the directive will be transposed to national laws, or you
yes
refer that the limitation should have been put in the regulation, and right now regulation is somehow in collision with trademarks?
Yes, we don't have in national laws the limitations of rights which correspond to the limitation, let's say, in copyrights. So I believe that there should be included in the design field because it's a rule, that it's a principle that we have cumulative protection for one thing, one intangible thing.
Okay.
Well, if we're talking about this critique, parody, and comments, in my opinion, it's not that much a problem as example of logo in this product examples. In my opinion, this logos are bigger problem for overlapping with trademarks, and they were not necessary to be put there.
Yes, I think we'll have to see how it really goes with the practice, because as we know, paper can take it all, and it's very easy to write new law, or even put an idea that might seem a very good one, and being actually moving forward to the evolution of life, of technology. But we'll have to see how it actually applies to our practice, and how the design holders will use it as their shield, as something that protects them. I think we don't have more time to discuss all the relevant questions. It was great to hear your points of view on the reform, And I hope that we'll maybe meet again, maybe as a webinar, or maybe we'll create some other discussion about that. But thank you very much for joining the webinar. And yes, that's not all that AAPPI has prepared for all of you in the nearest future. The upcoming webinar, Diversity and Inclusion Committee, Ageism, will be aired on March 18th. So keep your eye on the AAPPI LinkedIn profile and wait for the registration link. And also in my AAPPI will be starting registration for Yokohama, and I hope we'll see each other there. And maybe we'll discuss more about designs and all the things that happened until autumn. So thank you very much again. Thank you, Paweł, Marcin, and Krystian.
Thank you.
It was really
Thank
great.
you.
And
Thank you for your
let's
attention.
see next time. Thank
Bye.
you.
Thank you. Bye.